of Lieutenant General and General in my car.
Yeah.
That would subject me to the military court, and I would qualify. Under circumstances where I was not involved in the search of my car, under circumstances where not even my lawyers, only representative from my side, Chair, with this bill or law passed, it means that most of us will be subjected, or actually all of us will be subjected to military courts. Chair, just last year, I called the Honorable Obotho in finding out why the military had raided my home without following the rightful procedures, even at a level of a member of parliament where I know I am supposed to be summoned. Even as a civilian, it would require the military or any force to come in with a formal search warrant. Chair, the military raided my home, and I called Honorable Obotho to question him whether if a shadow minister qualifies to make an oath of a serving military officer. They found white Kitenji clothes, and they came and paraded and claiming that these were military uniforms. And I'm from seeing, when you look at the bill, page 88, clearly there are army Kitenji clothes, blue Kitenji clothes, which I think most of the designers around town are using. What would differentiate the attires of the military would be the symbols, the emblems that differentiate. There is no way you can tell me that a boot, a black boot, or any other clothing that does not have a symbol should be attached and gazetted to be a uniform of the military. I believe this is going to affect many, but even the creatives in the industry. This is something that many of our supporters of the NUP are being arrested. One is arrested because he's putting on a red beret that specifically has a symbol of the people power. One that is gazetted and accepted by the Electoral Commission, different from that of the army. Many of these young people that are being arrested are being subjected in the military court before the Supreme Court ruling. They are being subjected. Even up to now, they have not got an opportunity for their cases to be transferred to the civilian courts. Chair, when you look at the presentation and statement made by the Attorney General, on murder, specifically, he signed out that persons subjected to military law in the commission of, in his statement he clearly made for those that have made this crime with military officers. But then when you look at the bill, it is openly, it is murder. So it means that the courts, the criminal courts no longer have literally anything to address. These are things that can be addressed in the military court and the civilian courts, and there is no room that the military can try somebody who has not made any kind of oath. And this is something that we should totally reject. When it comes to the welfare of the military officers, we applaud you, the minister, because that has been our concern, that our officers need to clearly have a well-standard welfare arrangement that can cater for most of these challenges as they are serving the country. Thank you.
I have 3 members. Honorable Updf.
Wow. Do you know the problem we have in Uganda? I think these gentlemen, General Museveni, Muhoozi and family and the members, they do see Ugandans as their cows. They do see Ugandans as their puppets. They do see Ugandans as their slaves. So they will do whatever they want to do because they are the masters. And they will own whatever they want to own because they are the ones who's in control. So they are the ones to decide what you wear and what you can't wear, what you eat and what you can't eat, what to say and what you can't say, because they are in power and they are afraid of being get out of power. So bagenda kukola buli kimu kubanga they live in fear of what is going to come next if they are topped out of power. So they must put fear in everybody in this country by trying to limit you on what to use and not to use. But we need every Ugandan to stand up, change the status quo.
Katuntu, Honorable Kiwanuka.
I will have to applaud the minister and the PDF for 80% of this bill, especially where it concerns the welfare of members of the Uganda People's Defense Forces. I don't think we could have, or we should have, any contradiction, because all policymakers are very interested in having members of the UPDF catered for their welfare, including those that have become casualties. They are injured. How does the public look after them? And I think the bill goes a long way to address some of those. And I've got to congratulate you, Honourable Minister. However, there is only one aspect listening to my colleague and also following the public conversation. Only one. And we are shifting the attention of a very good bill to one issue: trial of civilians by the army courts.
Yeah.
That is all. That's where this contradiction is coming from.
True.
Nothing else. We should be speaking the same language.
Yeah, they are doing this because they do fear civilians. Yeah, they fear the power of civilians, but they don't know that them being where they are, it's because of the civilians. And now they are fighting the people that give them power. They want them to be powerless. That's why they want to put them in military court martials.
So what is the issue exactly? Mr. Chairman, I would like to speak with my head, but also with my heart. In conversations like this, sometimes we use our hearts, become emotional, and we forget the common sense. Or sometimes we are too brilliant and we don't think correctly.
Mm-hmm.
I want to talk directly to the court-martial officers who are here. All this problem has been caused by you. All this conversation has been caused by you. Why am I saying it? You failed to do what you are supposed to do in the law and veered into other things. And where you would have a legitimate case, like I'm going to support you on some aspects, here, you've spoiled your case. So as we give you a law, don't cause us more contradictions and problems. Let me give you an example. If there is this civilian Abdu Katuntu found with grenades, artillery pieces, why would, even if I'm a civilian, why would anybody have objections in me being tried by the court-martial? Because that is the purpose of the court-martial. These are weapons which ordinarily should be a monopoly of the UPDF. These are just war materials.
Yeah.
A civilian who is having this sort of weapons, caliber of weapons, really, we would not be so much having a wider conversation. But if you start to pick a helmet and that becomes, what do you call them, these people? Beret. Is it called beret? Whatever they are. And that becomes an issue. You are vulgarizing.
That's
the
fear.
issue.
Yeah, they fear.
That's what the problem is. In law, and the landed Attorney General knows this, we all agree, if you aid and abet a crime, you are as culpable as the principal offender. That's the law. And we will not be having this problem if you people were restricting yourself to real service offenses and civilians aiding and abetting crime. We will not be having this conversation. Please listen to us. But once you veer into other issues, because of other reasons, then you miss out on legitimate support. I hope you've listened to me, but I've looked at you, especially the gentlemen who are lawyers the other side. Please listen to what Ugandans are telling you.
True.
Just restrict yourself to the law and the purpose of the law. Let us go to the law now. Mr. Chairman, whereas the Supreme Court judges came to the same conclusion, all of them had different reasons. So, you see, somebody will pick one reason from one judgment, then he thinks that is the Supreme Court decision. And thus, maybe at some point, we need now to sit ourselves and reconcile or harmonize the reasonings given by different judges. Because there is no single judgment which gives the same reasons. All judges came to the conclusion that it was unconstitutional, but giving different reasons. So can we go and address the reasons within the different judgment, such that we talk from the same legs? Colleagues, you need to read those judgments. They are quite a number. And there is no lead judgment, except that the other one was the senior judge.
True.
Because if there was a lead judgment where all judges agree with the lead judgment, that would have been even easy. But the problem is every judge wrote his own judgment, but they concluded the same way. Now, to go back to say this is what court said, that's where I think we are having a problem. And we need to sit. I hope we get time as lawyers, read as lawyers, including the Attorney General's chambers, and we can harmonize. I hope we get some experts to give us some idea. You've invited them. And we can harmonize on that one, because it's quite easy to do that. Second, is it third? Any number. Mr. Chairman, let us look at clause 7. C. Clause 7C. Honorable Minister, why do we have this clause anymore in our laws? 7C. Members of the High Command as of 26 January 1986, whose names are set out in Schedule 3 to the Act. You know, I don't think it's very good drafting and legislating. To legislate for individuals. It is E. Yeah, it is actually E. This is not good legislation. That we are legislating that Abdul Katuntu is a member of the High Command until he dies. Really? I think we need to, first of all, the NRA has since then metamorphosized into the UPDF. It has moved on. Medals have been given. People have retired. I think the Army should move on. For example, in this particular clause, Honorable Minister, assuming one is likely to survive up to 100 years, just imagine that you are having a 100-year-old officer to be a member by law of the High Command. It doesn't make legal sense, really, even common sense. So I think at some point, maybe this I should be talking to the UPDF, not to the minister. At some point, you need to revisit this principle. The officers have served, we've recognized them, they have retired, let them live their own lives. They don't have to be members of the army organ, top army organ by law. No. No, I think we need to revisit this. And I hope at some point you concede and we move on.
Yeah, bro, they use this to own the army. Yeah, they are trying to tell you that the army is theirs. You know, those so-called the main men, you know, they are the ones owning the UPDF. Meaning, without them, there's no UPDF. You know, they are the ones to decide on what to do in UPDF. But why do we have some people to be a member of the High Commission? High Commission? Yes. High Commission? Yeah. For life. Why? And why specific people from a certain family? Why not all Ugandans? And there must be, bro, there must be something for, you know, that ono kubanga aveno, no kubanga aveno, nti waliwo ebigobererwa. There must be rules and regulations. Omuntu afuuka atya akulira UPDF. Okitegedde afuuka atya. Bino okubanga byonna weebine bano bakikola just for their own benefits.
Page 15, you like Uganda, such other commanders and experts as may be co-opted by the president to advise the high command. You see, if you are advising the high command, then you can't be a member. I think the high command can co-opt people to advise them, not necessarily as members, but to bring their expertise. For example, we have seen members of cabinet, but there are people who sit in cabinet and advise cabinet, not necessarily them being members of cabinet. You would find, for example, National Planning Authority boss or Secretary General of the ruling party. I don't know whether it's possible. Those who come around, they listen into cabinet and they can be advised, but not necessarily that they become now members of the high command. You need to look at this critically, because you need the services of advice, of experts. But you can't have an expert and then you are saying he's now a member. He's coming in as an advisor. And that's the power we need to give to the president to seek advice. Mr. Chairman, there is a good innovation by the bill of cross appeal, where you can appeal to the High Court. I think it's close. Clause 57. You see, I still have a problem. When you look at 2, clause 2, 225, clause 2. I don't know, Attorney General, whether you're there. Subsection 1 shall not affect the operations of any sentence imposed by a court martial other than a sentence of death imposed by the general court martial. You see, it means that you can only appeal about death and whether the trial was proper, but doesn't affect the sentence. Why should you have such a clause? That if somebody has been sentenced to life imprisonment, for example, and then the Court of Appeal has found that it was an illegal trial, the sentence is not affected. That was my interpretation. I could be wrong, because it said subsection 1 shall not affect the operation of any sentence imposed by a court martial other than a sentence of death imposed by the general court martial. So if you had other reasons, you could explain to see whether this particular clause is not going to be misread or misconstrued to mean that you can actually find impropriety in the sentencing, impropriety in the legality and of the trial, severity and or even leniency of the sentence, and yet it is not affected by the decision of the Court of Appeal. And why appeal to the Court of Appeal? I thought this is a subordinate court under 129. And subordinate to what? To the courts of record. Meaning, if it is subordinate, it should be able to appeal to the High Court because it's subordinate to the High Court. Why are we jumping to the Court of Appeal? Yet this is a subordinate court. The chairman, there are two things I want us to address about parallel or competing jurisdictions. Already there is a penal code provision. which provides for some of these offenses, unlawful possession of firearms, for example. And now all the firearms, you brought them here. What happens to the provisions of the penal code? Or we are repealing the penal code by necessary implication. Are we doing that? Because those provisions are there. And why are they there? It's because there are other weapons. For those of you who are used to weapons, me, I just see them. There are other weapons which are like for personal safety. For example, the small one, they call it a pistol. Yeah? It is now also listed, that one.
Number 1.
But I see so many people carrying them. In any case, since when did a pistol become a monopoly of the UPDF? The word used in the bill is monopoly. But I see so many people carrying them. I see even the police has weapons, doesn't it? The prisons has weapons, doesn't it? The Wildlife Authority has weapons, doesn't it? These private security people have weapons, don't they? Are those weapons which the police has a monopoly of the UPDF? Does the police need permission from the UPDF to hold those weapons? Does prisons need permission from the UPDF to hold those weapons? Because there are two categories of weapons, in my view. I'm sorry, I'm not an expert, but in my thinking. There are these which are meant for purely war purposes. I think Lieutenant General Herrero here will help me. He's the one who knows those things. This one you use to do very bad things to other people. No, that was your word. You know, those you use to attack enemies. For example, you know, like an artillery piece. There's this one with too many guns, too many bullets, or whatever it is. Yeah, or either Honorable Chama Sweat or the other one who said he was a... Okay, let me conclude. I don't want to excite people. There are those weapons, and Honorable Minister, you would get my support for those category of weapons, which we think are purely for UPDF. And no civilian should, under any circumstances, own, or even whether lawfully or even illegally, own that weapon. That one you'll have my support. But there are weapons which I think cannot be said to be a monopoly. You can't say monopoly, then you go ahead and you bring almost all weapons and you say they are what? They are monopoly. I think there is a problem there with the law, and we need to address that so that it's so clear. These people who are charged with the responsibility of keeping us safe, and they have been given equipment, we want to protect the equipment. That one they use to keep us safe. But the other equipment which you share, including with the civilians, some of these MPs carry them, by the way. Even other people in the street, they are carrying these small pistols, and so on, they do. So those cannot be your monopoly, and don't bring them as a monopoly. Then the other issue, Honorable Chair, I think just look at these classified materials. There are some which shouldn't be here, like this is shoes. Yeah, please. If we are to start looking at shoes, this one looks like an officer's shoe. Really, Honorable Boss, please. Stop this. Because people are going to start looking. So, by the way, this shoe is gazetted. Come on, it's for officers. Please, don't vulgarize the law, please. Because we are missing out on the serious aspect, and now we have gone to small little things. And you have taken us there. Please, I think review that, come back, and then we can move on the same page. I thank you, Mr. Chair.
Wow.
We have a special
Oh, that is Abdu Katuntu. Exactly. Bro, we need to tell these guys right direct in their faces. what's wrong and what's right. Bro, they are bringing their intimacies, bro, their thoughts, their dislikes to become laws. Their fears, they are making them laws. Because they don't want to leave power. So they want to put intimidation on everybody and on everything. That's why buli kintu kye balaba baagala ki owuninga nti kyabwe. Okitegedde? Ne batandika ne Uganda ne babeera nga buli munnayuganda akeera ku makya kuyimba kuba ngoma ng'ayimba nti Museveni genda bajja gazetinga engoma nti no it's a military attire, it's a military wear. Bajja natuka bagazeting okuyimba nti no that's a military wear. Kubanga bwe tuba tukola mu kyaka bwe tubeera mu magye tuyimba adui nani chapa mguu n'olwekyo n'ennyimba zaffe bakirizibwa kuyimba. If we allow this to happen, meaning everything will be possible. Ekyaba kujja agambe ekanzu kati za magye kaba mutera ku mataputagulanye na monopolizing ekanzu nga buli mwana wa Nup buli munayogera munamukyukakyuka yambala kanzu ne bakibayinga countrywide nga bambala amakanzu buli lunaku. Era General Museveni ajja kudda mu parliament agambe I want to gazette kanzus is a military attire. For them, everything will intimidate them. Kasabala nga abantu bangi bakyenyigiddemu, they will get intimidated. They are playing with a generation that's full of creativity and they love what they are doing. Nebo no twala ovulo no twala kawunda no twala engato no yuganti bya amaje wangola abantu babyambala nnyo moro bajja kwambala ekintu ekya bana asala ndo katugenda kwambala nga Gomez ngana zozuwera. Bro, we love what we're doing.
Address the issue to do with involvement of the DPP. At what level can the DPP come in, especially at the point of sanctioning files? Because he has all that knowledge and the knowledge how to handle the files. Because as far as the court martial is concerned, that department is purely missing. It is only the prosecutor who is sanctioning and prosecuting. Also, the issue to do with the security of tenure. As far as since they have hinted about the issue to do with the Judicial Service Commission, I think these judicial officers should be given security than to give them a timeline that you are for independence purposes. That the contract can be for 5 years. If you are a judge, you can only administer justice when you are sure that even if you have decided a case in a wrong way, you cannot be transferred or fired, or your contract cannot be renewed. I think that issue should also be revisited, and whoever works in court martial, if he's a judge, his security of tenure should be as the security of tenure in the civil courts. And lastly, Honorable Attorney General, there is this case of Second Lieutenant Ogwanga Ambrose, Supreme Court number 048 of 2021, in line where the Supreme Court was banning anyone from when you have taken the route of when you have been prosecuted in court martial, that you cannot now shift to the civil court. I'm inquiring whether this clause 63 at page 63 is intended to cure that. Thank you.
Of law. Thank you very much, Chair. But this morning, where Parliament advised the general public to come and attend this committee by end of today. This bill came to Parliament yesterday, and that advert is saying the general public must attend to Parliament today. I came to seek your clarification, but also request this committee. Now that matters in this bill concern the general public, because whereas the Supreme Court ruled that civilians are not supposed to be tried in military courts, and the bill is hell-bent to bring back the same, Chair, I want to plead with your committee that you give ample time to the general public to come and express their views, because most of them could have missed the advert the way I could have missed it had it been not my voter who picked it. So that's my request to the committee. It's my request to the minister. Do not put UPDF. UPDF is an institution for the people of Uganda. Whenever it is put against the people of Uganda, it becomes very dangerous. Whenever things like this come and people are not given chance, Mr. Chair, it will be very dangerous. So I am pleading with you on this. Secondly, I wanted to hear the minister, and I was ready to clap for him. Had he stated clearly why he still insists on bringing a matter where the Supreme Court had a ruling that civilians are not supposed to be tried in court-martial. I was willing to clap for him, unless, unfortunately, he wanted to be clapped for other reasons that were not. We wanted to hear that. Why the bill is still insisting on a matter where we have a court ruling. And lastly, Chair, my brother, the Honorable Katuntu, highlighted somewhere that, you know, civilians can be tried or may be tried if they are found with weapons. And this is where we need a very big clarity, Chair, in this bill. We have situations where the military have planted weapons in people's homes, civilians' homes.
Yeah.
They have planted them. They have planted these, what they call military attires and everything. They plant it in your home. They arrest you today. After arresting you, they take you to your home, and they themselves, they know where the weapon is. So how are we going to deal with that? Because it has been a problem. I'm a civilian, Patrick Insamba, I've never held a gun. Tomorrow they find a gun in my home, planted by the same military. It becomes a very big challenge, and this law must come very clear on that. Then the one last bit. The military always has come out to claim our attires. I come from National Unity Platform. True. One day I picked my beret and gave it to a military officer. Said, put on this one. The military officer told me that is not ours. True. Because ours is different. And what differentiated it is the emblem that is there. True. So even here, it must come out clearly in the law to state that the color and the emblem that is put there, not only the color, to say that color blue or color red. Thank you very much, Mr. Chairman.
Wow.
We cannot time to review what we are thinking about, but I think the law is talking about similar. That if I looked at it from a distance, what would I think that person is? If, for example, a person is running out of this building, putting on this uniform, wouldn't you ordinarily think that is for the soldier? That is where it is supposed to avoid confusion. So if you have a red beret like you have for NUP, if you're in a crowd, a person looking at you at a distance, would they think it is NUP or military police? That's the issue. So when the law is looking at those issues, it is looking at about the similarity and likely to confuse. Obviously, there will be extensions where we are discussing black shoes. So that is the comment on that. But I think that is a policy issue we need to look at and understand
how can we best, what is it that we would look at as contradicting what the army uniform would be. And Honorable, the question of framing is criminal in itself. So, but that is another matter. If they are framing someone and putting a material in their house, that's criminal in itself. So, we try to write a law, but we write the law for human beings. Human beings, by their nature, we try as much as possible, but they are going to fail in certain instances. That's why you have the laws. So it is that framing is definitely criminal, and we need to address it. And I think it's for us to think about what kind of safeguards can be put in place on both sides as Parliament. What safeguards can be put in place to ensure we address that issue. On the issue of Ogwang that Honorable Abdallah raised, yes, in that case, the court faulted the use of appeal as made by an instrument signed by the minister. The court said in the Ogwang decision that a minister cannot vest jurisdiction of appeal by an instrument. Jurisdiction of a court is vested by Parliament through principal legislation. So by bringing this here, we are asking Parliament to grant the principal jurisdiction not by statutory instrument, by principal legislation. So yes, it would be curing that. On the security of tenure, we discussed it and we can continue discussing it. The Army has a challenge on the stages of retirement, which are not necessarily the same as ours in the civilian life. In civilian life, we say a judge will retire at 65, and that person leaves the public service. But in the Army, people live at different stages of life. So some people live at 45, others at 50, others at 55, others at 60. So if you say that the person shall retire from the service of the court martial at, say, the age of 60, that person may be way past the stage of their retirement, but that's a consideration we could have. On your recommendation to have the DPP participate in prosecution, that would contravene Article 1, Honorable Abdallah. You had proposed that we have the DPP sanction the charges under the court martial. And I was saying that would require a constitutional amendment because the Constitution under Article 123B specifically prohibits the participation of the DPP in matters before the court martial. A number of issues. I'm going to leave the issue of the monopoly of the Army and etc. to the experts in these weapons. But what I know is that for the AK-47 to be used by police, it needs to get permission from the Army. That I know from my interaction with them. For prisons, even private firms to use AK-47 must get the permission of the Army. So, but they are here. They will be able to explain to you how that works. Then on competing jurisdiction, I see what you're saying. I think the only difference here is that if I have a firearm lawfully and I shoot someone using that firearm and I shoot someone and injure someone, there is no question of me going to the court martial. It doesn't exist because I have the firearm lawfully, but I've committed an illegality with that firearm. Yeah. Yes. Now that unlawful possession of the firearm will be charged by the court martial. But if you look at the law, if you have an unlawful firearm as an individual and you go and commit murder without the assistance of a serving officer, you have the firearm illegally, you go and commit murder using it, that you will be charged in the court martial for that unlawful possession of that firearm. So if you have it lawfully and you use it for an unlawful act, you will be tried by the civilian courts. Why? Because at least you made the effort to go and report yourself that I have a gun. So that is the thing. Now, on parallel jurisdiction, I think the issue would be you can be tried in both places, and that happens in many instances. You can be tried in both places, but I think the issue is that both of them have jurisdiction. Both the High Court has jurisdiction over the murder you have committed, and the court-martial has. The issue that we have is that if you are in concert with a soldier, then the court-martial also has jurisdiction. Now, the problem we are having is that if you take the soldier the other side to be tried in the court-martial, and you take the civilian this side, the trial of the... Yeah. In two different places, yes. So the issue of possession of the firearm and the detail of it is what I'll leave to the experts. Because some experts sent me here, like for example, there is a bayonet which is attached to the gun. That bayonet which is attached to the gun, they're not expecting you to find it in a shop roaming around with it. That bayonet is the preserve of the army. So, but they'll give you more detail. Appeal to the Court of Appeal. We're just borrowing an experience from the industrial court. We're just borrowing an experience from the industrial court, where the industrial court decisions are appealable to the Court of Appeal. But that, again, like I said, the jurisdiction of any court is determined by Parliament. Clause 57. I wanted us to, Honorable Katuntu, you raised clause 57, and maybe it may be our drafting which we may need to clarify. Clause 57. Any party to the proceedings of a court-martial who is dissatisfied with the decision of the court-martial shall have the right to appeal to an appellate court on any of the following matters: legality or propriety, legality or the whole or part of the sentence, severity or lenience. Subsection 1 shall not affect the operation of any sentence imposed by the court-martial other than the sentence. So here, what we're trying to say here is that if a person is convicted of and sentenced to death, you cannot go to the Court of Appeal and say, what is the legality here? What is the severity here? The person sentenced to death should be at liberty to bring whatever issues that they may want to bring. Secondly, you cannot execute that death sentence before this person has exercised all their appeals. And if the person is appealing to the Court of Appeal, you must wait for the Court of Appeal. But if a person has been sentenced to 20 years in prison, he starts serving the sentence. So I think it's an issue of drafting.
No, that's bad. This is bad drafting.
Yeah,
I hear you loud.
Yeah.
But this is not what
it
has to be redrafted.
When you're speaking to it, I could understand where you're coming from. I think we'll need to clarify on the drafting there. And then on you at page 15 and on the composition of the court-martial, I think what the military was looking was co-opted. This person is co-opted. What this provision is saying is that the president has the power to co-opt someone into the High Command. So that is what EU is saying. And 7E, people should be a member of the High Command. That is a policy issue, like you said, they will help us with. What is the issue? I agree with you. The issue of civilian in court-martial. I want to end with the most controversial, because it was a question that channeled through almost every question. What did the court say? Because, and I want to go there last, so that I can leave immediately after that. But but it is a matter that I need us to be clear about. I think, Honorable Nyeko, what my statement says is exactly what the bill is saying in 31D. What you're raising is in 31D, the clause 31D about what can be murder. This one here does not give the court-martial. 31D does not give the court-martial the jurisdiction to try murder. It doesn't give them the jurisdiction to try murder per se. It can only try murder if it is aided and abetted by a soldier. So if I'm a civilian and I go and commit murder on my own without anything, without the assistance of a soldier, the court martial has no jurisdiction over me. Yeah, but if I committed it, if we went and broke into, you see the issue, and colleagues have spent some time with these men in uniform, and they've taught me a few things. The issue here is there are skills that they acquire in their training, which are not available to you, a civilian. When a soldier is jumping over a wall, he has a skill which has been given to him in the military to use to defend the country. Now, if you, a civilian, were to get over a wall, you may need a ladder, ropes, and etc. A soldier may not need that help. So when this soldier comes and jumps over the wall, then opens for a civilian, then you go in and commit murder, you have used a skill available to a soldier in the commission of your offense. So what the military is telling you, you want to commit your offenses, go and do it alone. If you do it alone, the court martial will have nothing to do with you. But if you go and involve a soldier in it, you are bringing yourself into the ambit. That's what that provision was saying. And Honorable Mpuga, you are talking about what provisions give, and I hope I understood your question to mean what in this law makes the court martial a court. If I understood it correctly, then I refer you to clause 35.9, clause 36.13, and clause 38.9. The creation of a court is by vesting it with jurisdiction. The moment the parliament vests a tribunal or a court with jurisdiction, it has become a court. So that's what deals with that. On the issue of the vice, I think that they've had Honorable Keyo.
Can you clarify? And you see, that's where the Honorable went on to ask, why then appellant jurisdiction is from the court martial to the court of appeal? Is it then a high court?
No.
What form of court is it?
You see, the jurisdiction, I think let's not get into a stage where we believe that this jurisdiction is dropped in a particular way. For example, for appeals to an election petition, this parliament said you will not appeal to the Supreme Court. So what this parliament vests you with is what you use. The industrial court was vested with mandate and sent to the Court of Appeal. It was by this parliament. So the Constitution did not tell this parliament where to vest the jurisdiction. So you can vest the jurisdiction.
No, but you see at that point, as you realize, the court, the industrial court, was not...
The conversation you'll have, but you must remember that the industrial court also has 2 civilians who are not necessarily legally trained.
Oh.
So, but that's a conversation that what I need to state as a matter of law, the decision on the jurisdiction to be granted to any tribunal or court vests with the parliament. So we are asking you, parliament, to grant the Court of Appeal jurisdiction over the decisions of the General Court Martial.
This is just for your take home. I beg to disagree with the use. Yeah. Okay.
Me, I've asked you, and I've told you what we think, and the reasons why we think so. Now,
Mr. Chair,
okay.
we are not trying to think,
yes,
so that we move together with the Attorney General.
yes.
I would rather the Attorney General listens to us, thinks about it, like we are listening to him, and we do the correct thing for the...
Are you persuading the Attorney General such that the appeals go to High Court?
Yes.
Is that what you are saying?
Yes, that's what we've been saying.
But
he can think about it if he thinks it makes sense.
But it's also important.
Or you are leaving it to us just...
We shall think about it and also share with you whatever other material we can find on this.
But it's also important to take note of what he has said. Jurisdiction is really our mandate. Yeah.
Responsibly.
Yeah, sure.
Okay. Civilian, the issue of schedules, I think the issue of the schedules, we are going to have a conversation with the minister on that, and we understand what these schedules and explain them a little more. The experts are here on those schedules. Dry ratios, I agree. I agree that because if for example you take the fuel of soldiers who are being sent to war, and you in concert, you a civilian in concert with an army officer, you decide to steal the fuel of the army. Why should you come to when you're stealing the things of the army, why is it okay to go to the army, but when they are trying you say, now me I'm a civilian? Why don't you remain a civilian and stay away from the things of the army? So Honorable Chairman Sweat, I agree with you. If they find you with army rations, what are you doing with army rations? But I think the issue again goes back to what safeguards have been put to the concerns of the members. Independence of the court, and I think this was Honorable Odu raised the issue. I think independence of the court is, like you said, is a wholesome issue. And independence of the court starts from independence, impartiality starts from composition, how they conduct themselves, and tenure. All those lead to independence. And I think the Chief Justice addressed himself severally on this issue at page 193 of his judgment, and taking oaths. He talked about taking oaths that you are talking about. Taking oaths is one of the issues of independence. Impartiality, both subjective and objective, is legal qualifications is part of the independence. How can you be independent rendering judgment when you have no knowledge of the law? Composition was part of this, tenure, manner of appointment. So all those are part of the independence. So if what we are trying to do here, honorable colleagues, is we are trying to clothe the General Court Martial with all these different tenets to try and give it an independence. Now we'll ask for your guidance if you think there is anything that we have indeed left out, and we shall.
Because you seem not to have understood me. I was addressing the two questions of impartiality and independence based on the triangular relationship between the three arms of government.
Yes.
And I think that is in the army, the oath to obey, maybe you are army commander or something like that. So if you give the example now of what is happening, and a brigadier general is now presiding over, and an order comes from a superior officer.
I think the most important...
That's what we are talking about.
I think the most important thing is that this oath that we are talking about is in the Constitution, the other one is in the Act.
And I can say there is evidence that in one of the proceedings of the court-martial in this country, before a decision was taken, it was taken to be discussed in the High Command, whether it should proceed. History has it. So that's the kind of interference we are talking about. That if a court that should make a decision then says now, we go to the High Command, whether now we should do...
and honorable...
So that's what I want
that's what we are trying to cure here. So you can also assist us with your guidance on what you think we should add. Because we have put for appointment, we have put for tenure, so you could also add and say, I think you may want to add this aspect to make it better, but we will be happy to.
No, let the record be clear that I have said it is unconstitutional under all circumstances.
No.
To try. No, I just want your record, so don't tell me to add.
I am going to show you
to escort
when I
you
end, because I said I want to end with that. I want to show you that you are wrong, that not even the Constitutional Court said that, not even the Supreme Court said that. But I'm going to get to that. I said it was the last one. So now on the definition of service offense, the purpose of amendment of this service offense, I think we need to be clear. The Act as it is now makes the court-martial try civil service offenses and any other offense made under any law, which the court in that judgment called the civil offenses. What we are trying to do here is by saying no, service offense means only that offense which is under the UPDF Act. So all the other offenses which are in other acts is not a service offense. That's what we are saying. Then Honorable Brandon, I think I was talking about Jamil Mukuru. I think Jamil Mukuru's case is slightly different because Jamil Mukuru is charged under the International Crimes Division Act, which is a manifestation of the Rome Statute, which has a different jurisdiction. This is dealing with genocide and different things. So when you say that Jamil Mukuru was being tried in that, it was being tried there because of Section 9 of that particular act. Now, that act that we brought in, Section 7, 8, and 9 deal with genocide, crimes against humanity, and war crimes. And that is specifically derived from the Rome Statute. So that is the explanation why. So when we entered the Rome Statute, we agreed that if a person commits such kinds of offenses, they will be tried in a court which has structures and jurisdictions which are different, which are similar to the Hague, to the ICC. And that one has pre-trial chamber. It has a different procedure, totally different from our criminal justice system. Honorable Chair, now I think what Honorable Katuntu said is important, that we will need to come here, and I've tried to, we are working on pointing you to the specific pages, but it's going to require that every member takes time on their own to look at the judgment. But we are going to we are preparing a guide. I had started on it last evening, but I wasn't able to finish. A guide on the pages and what was said by every court. And I can state, honorable colleagues and members, without any fear of contradiction, that the court did not, the Supreme Court did not at any one point say civilians cannot be tried in the general court martial. I want to state that as without fear of contradiction. The Supreme Court did not say that civilians cannot be tried in the court martial. Like Honorable Katuntu said, different judges went through it in different ways and arrived at this different conclusion, to the conclusion that the court martial as it were constituted, and the way it had been set up in the law was not constitutionally set up to try civilians. And on the issue of the offenses, they said they were vague. So, colleagues, it is important that we all really get an understanding and an agreement on what the Supreme Court said.
Now, if we are putting in place laws governing a court martial, now, why are we including civilians in the court martial? Civilians, are they army men? Are they UPDF officers? Police officers? Prisons officers? Why are you including civilians in the court martial? Because you want to use your concocted judgment, concocted evidence, concocted hallucination to formulate the civilians, to force them to be charged in the court martial, yet they are innocent. Because you don't have evidence, so you want someone whom is scaring you. You must put intimidation in his mind and head, plus those following him, that when you do so, when you try to top up this government, if you try to fight this government, take it out of the power, then you become a military officer, that you must be tried in a military court. Kiryowa Kiwanuka. Bwengano njakuja kujeno Museveni n'ofuse w'amagye. Nyina okutwalibwa mu kkooti y'amagye. Togamba Museveni anakuggibwako b'amagye. Kuba bannayuganda bannannyini buyinza. Abalenzi.
And I have got some of the pages here. It's so far I'm at page 11. But each court was saying the court martial as it is set up, where you're not appointing persons properly, where they are not lawyers, where there is no independence, that court martial that you have there cannot try. But I'll just quote from some pages to exactly say what I understood the Supreme Court to say. The Honorable Chief Justice at page 126, 127 says, while there is no international treaty to which Uganda is a party, which contain an express provision prohibiting trials of civilians by military courts, there is nonetheless international consensus that the jurisdiction of such courts needs to be restricted. That was what they... At page 134, he says, it is clear that international jurisprudence, even if the move is generally to restrict civilians in military, the tribunals, the practice oscillates between complete abolition of civilians in trial courts and trial of civilians only in certain cases of an exception. He went on to say the trial of civilians by special court should be done only in exceptional circumstances. That is at page 136. At page 141, he says, I take cognizance of the crucial need for military courts for the maintenance of discipline. I also note, and which thereby ensures the defense of and security in Uganda. I also take note of the fact that there may be need to extend jurisdiction of military courts to cover civilians who fall within the few exceptions in application of the law as it obtains to other jurisdictions. At page 148, in conclusion, for the blanket trial of civilians, in conclusion, the provisions for the blanket trial of civilians, in the military courts, either as principles in 117H or as accomplices, does not satisfy the limitation requirements. The unconstitutional lies with the act of trying civilians in civilian courts under those provisions and constitution. So we need to read these provisions. We need to read the judgment of the court in extenso, in full, to understand what the court was saying. I'll go now to Honorable Justice Monica Mugenyi. Honorable Justice Monica Mugenyi also concluded that I think I would therefore hold that the majority that the civilians that aid and abet civilians that are military persons in commission do offense in the service of, do by their actions subject themselves to military law under the Act. At page 22, she says, I do additionally find that the provisions do not constitute exceptional circumstances under which the trial of civilians in military courts should be justified. And to that extent, it's inconsistent with the provisions of the Constitution. Justice Mwonda agreed with the judgment of the Chief Justice. Justice Pase Mugenyi said, Justice Pase Tuaise, Knight Tuaise, says, in its present state, the General Court Martial, though lawfully set up by an Act of Parliament, deriving such powers under Article 129(1)(b), or is, in its present form, competent only to try matters relating to discipline of members. So she's also saying, in its present form, it can only try discipline, but cannot try things. So I'll share, Right Honorable Chair and members, we are going to write out and try and point out to you the exact provision, the exact paragraph where the judges said whatever they said on the issue of thing. I think for me, what I understood this to mean is that civilians can be tried in the General Court Martial in exceptional circumstances. The question for this committee and Parliament, what are those exceptional circumstances? What we have brought to you, colleagues, is what we think are exceptional circumstances. I beg to submit. I thank you.
Chair, justices of the Supreme Court, having made all those analyses, in the final orders, they did not put that. Why didn't they reduce that into an order of court? You will explain in there. All that I think, because when a judge is saying, I think, and I did this and this, in the analysis, but in the final orders, stop short of putting that in their final orders. Later, I also want you to confirm to this committee two things. If we process this act, and by Friday it is passed, and by Monday it is signed, will it apply to the 400 plus people who are still being held in defiance of the very Supreme Court? Will they be tried under the new act? That's a question I want you to answer. In case the act
first
comes
of all,
into force.
If the Parliament...
No, let me... Then thirdly, why do you think their lordship said transfer all and did not say use others, transfer all. Those three, if you can answer now, it's okay, but later it's still fine.
Chair, why we are trying to, before the case was committed, the army has lost trust, and given this power that it can easily come up with a case and it claims conspiracy, and an individual who is a civilian can be added onto another case. It has been realized that many cases, somebody is picked from nowhere and then added to one similar case. And this brings it to that point that they have broken the trust, that we cannot give them such power. As well, how far with transferring all these cases that we are sent to the civilian courts?
Honorable Chair, before he takes leave, as part of the framework you need to have independence, I have not seen anywhere a privileges framework for the persons so appointed under this proposal. Are they equivalent to magistrates grade 1? Are they high court judges? Where is the privileges framework as the extension of security and independence?
The Army will tell you that if they were to ask for the privileges that we enjoy, our pass may get finished. So we want to encourage you to leave the issue of privileges. And as far as the Army is concerned, we are going slowly, increasing salaries and etc. So these issues of privileges, the privilege to serve is there. They are serving. I discussed this with them, that's why I'm quickly answering. It is for them a privilege to serve in the Army. But the security of tenure, yes. Broken trust, that is a view that you hold, but I think we can work on rejuvenating this trust if you think you have lost it, by putting in place the safeguards that you would like to put in place. I don't think it is wise for us to throw out the bath waters because you see the court-martial colleagues has been here for at least for the NRM government since 1986. By legal notice number 1 of 1986, the court-martial has been here. And we were happy with what the court-martial was doing until a few cases that we are having a problem. Because I hear some people are saying they are happy with the court-martial, you say you're not happy with the court-martial. I think together we can sit down and say, what is it that we do not like? What is it can we do to make it better? I don't think it is wise to throw out the child with the bathwater because of a problem. Why the judgment says so, Honorable Dur, I think like Honorable Katuntu said, we shall sit down and go through this because I have told you my understanding of the judgment. And I am reading to you what I am reading from the judgment of the court. That is my understanding of that judgment. And I'm going to share with you what my understanding, because I've been hearing many people saying this. And when I read it, I read a different thing. So we shall sit down as colleagues in Parliament and say, is this what the court said? Because I'm sure next they may say that I am misquoting the judge. So we shall get a certified copy from the court, bring it here and say page 44 says this, page 46 says this, so that I am not accused of bringing new words into the judgment of the court. So that's really my understanding. Retrospective effect of legislation, you're the legislator. If you're magnanimous enough to give us retrospective application of the law, we'll be happy to take it. No, he asked a question, I'm just answering. So, why did they say transfer all civilians? Because the court-martial as it was constituted was not fit to do the job. But, pardon? I really can't answer that question now, because you see, honorable colleagues, when I came here the first time, and I told you that I had forwarded the matter to the DPP, some of you really harangued me for attempting to interfere with the power of the DPP under Article 120. It was in this house. Said, why are you writing to the DPP? I said, okay, I just forwarded the judgment of the court, and the judgment said these things have to be taken over by the state. So now I dare not write to the DPP to tell the DPP how to do their work. So I can't answer that question because you advised me to stay away from the DPP. this parliament. I thank you.
Thank you, Mr. Attorney General.
Because, Chair, this is a lifelong document, it's a living law. And we're talking about pension, we're talking about wage, which shall be over time changing. So, 718 billion was just like the initial costed bill. And about the salary structure, Chair, we at one point the military was operating under the salary structure of Ministry of Public Service, or the public service structure, which had fewer segments than we have now. So we had overlaps, and we had special overlaps, which failed us to segment this structure according to the rank or the ranks in the army. So
wow, beba abantu bammwe kale kabeewo obuyinza naye ndi sure love amateeka ge bakola olwaleero egagenda obavunaanibwamu beekolere ge bagenda avunaanibwamu beekolere gye bagenda okumaliririza